If a landlord violates the rent stabilization law, can the tenants get triple damages? To find out, you have to read Casey versus Whitehouse Estates. But it's 4 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of Casey versus Whitehouse Estates, published by the New York Court of Appeals on March 16th of 2023. The citation for this case is 2023 New York Slip Opinion 01351. The issue in this case is how are overcharge penalties calculated after a landlord violates the rent stabilization law. The complicated part about this case is actually the background you have to cover to understand the context of this case. Very briefly, after 1969, there was sort of a rising housing crisis where the rents were became so unaffordable that most of average New Yorkers couldn't afford it. So they introduced legislation and passed it that introduced the rent stabilization law. Under the rent stabilization law, certain apartments that are eligible, meaning more than 6 units in a building of a certain vintage, if the apartment is classified under the rent stabilization law, then the landlord doesn't have the ability to just charge market rate, whatever they can get on the open market. Instead, they have to follow limited amounts of increases that are statutorily allowed and decided every year to year, basically. And this creates a tension because the landlords want to charge market rate. They want to get the most they can get. But the tenants have this right under the law that they can't be charged market rate. If a landlord decides to skirt the law and violate the law by charging more than they're allowed to charge under the rent stabilization law, then there's a penalty assessed against the landlord. And what that penalty is depends on what kind of culpability the landlord has. If it was inadvertent, if it was a mistake of law that led to that decision, then it's just the overcharge plus interest. And you go 4 years in the past and you look at what the base rate of the apartment would be plus any allowed increases, and that's how you calculate the overcharge. If, on the other hand, it's a willful violation, if it's part of a scheme on the part of the landlord to deregulate rent-stabilized apartments, to do this on purpose, now the penalty is much more severe. It's treble damages, 3 times the overcharge. And there's something called the J51 tax abatement, where basically if a landlord tries to make an improvement, if a landlord makes a capital improvement to an apartment building or an apartment, he can then, they get this J51 tax abatement and tax exemption. So it helps the landlord. And there was a case in 2020 that said that if a landlord tries to charge more rent because of the improvement, but they get the J51 tax benefit, then they can't do that. That's a violation, and it doesn't take it off of rent stabilization. It doesn't unregulate the apartment. That's the case of Matter of Regina Metro. Okay, so what are the facts of this case? The facts are, on October 14th of 2011, tenants of a rent-stabilized building in Manhattan brought a class action lawsuit against the building owners, managers, and landlords, alleging rent overcharge in violation of the rent stabilization law. The plaintiffs then moved for summary judgment. They said, we should win without a trial, alleging that the owners engaged in this willful, fraudulent scheme to deregulate. They allege that path that gives them treble damages. They say that the landlords failed to produce adequate rent records, and that the special default formula, which gives a lot more penalties, should be applied. Supreme Court granted summary judgment on behalf of the plaintiffs, and the appellate division affirmed. And it goes to the Court of Appeals, and they say this is not a complicated case. They say this is that same factual scenario as was in Matter of Regina Metro. They say this is basically the same situation where the owners tried to charge more rent based upon a J51 tax exemption application of a capital improvement, and that was a mistake of law. They're not allowed to do that. The same way that the landlords in Matter of Regina Metro are not allowed to do that. But it's not a willful violation. It's not a violation that shows a fraudulent scheme to deregulate. Rather, it's a mistake. The landlords were just wrong about whether they could charge more rent. And because it's not a fraudulent and willful scheme, the plaintiffs don't get the benefit of that treble damages penalty. They have to only get the overcharge plus interest penalty. And that's the case. Basically, it's just a reapplication of the Matter of Regina Metro. And that's the case of Casey versus Whitehouse Estates. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.